David Whiting is here once again to help you through the legal dilemmas of life. The phone number is 1300 222 774. David, welcome. Good morning.
Good morning, Raph.
I just wanted to mention something about fines.
Yes, there's a proposal legislation that might start in December which would have the effect of allowing a prisoner to go to a magistrate and seek to have their infringement fines waived. Whereas normally what you do is you work them off at something like $160 a day. And the proposal would be that if you are a particular class of infringement getter...
Non-violent, I assume.
Yeah, I don't know that would necessarily follow, but the plan would be that you could go and seek assistance from a magistrate.
Why? Because it's an unnecessary burden? What's the rationale?
Don't know what the rationale is. I mean, clearly, for some people at some point, the burden of the infringement notices simply becomes insurmountable. You know, I'm never going to be able to get over this pile. What do I now do? I don't know what the answer to that is. I do know that if you make it too easy to avoid infringement, the consequences of an infringement, then you're going to run the risk as well. Then the answer will, you go back again and again. You look at the people who get tens of thousands of tolling offences.
Stealing problems,
yes. Yeah. So I don't see that getting any easier in the short term.
Do you think it will happen? Because the obvious retort, and I've already heard this in the tabloid media, is, well, hang on, I get a fine, I have to pay it. How come the prisoner, outraged, doesn't have to? Do you think it'll happen, the change?
Yeah, well, I think it will be. I think it will become wider. There has to be a method of dealing with these insurmountable problems. It almost like becomes a debtor's prison. We've called them a fine. The CityLink stuff particularly is more. My brutal response is that it's to ensure the integrity of the revenue received by the tolling operator.
Yeah, it's a massive public obligation on behalf of a private operator.
Yes.
You and John have covered that extensively. Let's get to calls. Daniel's called from Mount Eliza. Go for it, Daniel. You're through to David Whiting.
Morning, David. Morning, Ralph.
Hi.
We've got a wedding coming up and we've engaged with a marquee supplier. And
Yes.
we've been going back and forth to try and get the relevant items. And we eventually sort of got to an agreement about some items, but we're always unsure about, because of the date, it was in advance, so we're looking at New Year's Eve, and we were starting to finalise items around February of March.
Yes.
Of this year. So
10 months out.
10 months out, yep.
Yes.
And we always knew that, look, there are some items, we don't know the exact items, we want to change some things, and they had led us on to believe that, yes, you could change some things. So about...
Well, when you say some things,
yes.
Are you talking about getting glass or silver salt and pepper shakers, or are you talking about a marquee for 100 versus a marquee for 150?
Yeah, correct. So in terms of the marquee...
You've covered the field beautifully, Daniel. Which?
Yes, so we're looking at the marquee, so the size of the marquee.
Right. So I suppose if I was the marquee provider,
yes.
I'd really want to lock in a hire as soon as possible.
Yep.
And so long as I had flexibility, I would continue to accommodate your changes.
Yep.
But does that mean I can't take a contract with someone else while you're still thinking?
So we'd actually paid a deposit with this supplier.
Yes.
So
and what was the deposit for?
The deposit was, as far as we were aware, to lock in their services for the date. So
No. I'm and the answer is they'll provide you services in the day. But if you were to turn around and say your starting point is I want a marquee of X size.
Yep.
And which say, okay, well, we'll lock in the marquee. Now we'll deal with tables and chairs and stuff and cutlery and crockery and wine and food and all the rest of it.
Yep.
Or did you think it was simply a blank slate until such time as you made the call?
No. So we had a quote that was provided around the marquee, chairs, tables, glasses, etc.
Yes.
They were happy to make changes to increase the order, but when we wanted to decrease the size of the marquee, they wanted to charge us a cancellation fee.
Right. Does that mean they couldn't provide you the smaller marquee?
No, they definitely could. So they came out and did another site visit and mentioned that they could.
What was the change in size, Daniel?
So the change in size is going from, let's say, a 19 by sort of 20 marquee, 19 by 6 marquee.
Yes.
If that's right, to a 6 by 6.
Oh, wow, that's an extraordinary change in the size of the marquee.
Sorry, by 6 by 9 marquee.
Right, but you've cut it in half.
Correct.
Yes.
So the order's gone from, to give you an idea, from about $14,000 to we still want to proceed with a $6,000 order.
And what's the cancellation fee they want to hit you with?
$3,000.
Yeah, I suppose the question then becomes, Daniel, as to whether they're able to, in fact, find a hire for that large marquee between now and then.
Yep.
That to me would be the issue. So if I was the marquee person, I'd say, well, do I have a commitment to a 19-metre marquee or not?
And Daniel, I'm assuming you signed a deposit form or paid a deposit, and the explicit or implicit agreement was for a big marquee.
Yes, correct.
Does it say that on the paperwork?
So it says what the items are.
Okay, so it's specified for that. And my view is that, if you wanted metal instead of glass, salt and pepper shakers, there wouldn't have been an issue.
Yep.
But what you're now doing is you're moving from a $14,000 hire to a $6,000 hire.
Yes.
And their concern will be whether or not they're able to find someone who'll take that marquee. So if they give you what amounts to the $8,000 allowance or adjustment,
Yep.
how much do they run the risk of being out of pocket by?
And they can legally charge that change.
Well, it depends
because of
on the
deposit?
contract they've signed with Daniel, but I would be, in a sense, that the suggestion is that I've made a commitment to you to provide you that size marquee.
Yes.
You don't want it anymore.
Yeah.
What
so
ought the consequence be?
So what we've relied upon in dealing with them is that verbally 3 different people from the same company have indicated to us that we are able to change things. So if we wanted to, say, expand the size of the marquee, we could. If we wanted to decrease the size of that marquee, we could.
Yes.
It wasn't specified, well, how much is a reduction?
Well, a reduction to what would be my answer.
Yep.
Look, if you think that the terms in the agreement you've signed with the venue hire are unreasonable, you can take the matter to VCAT, and VCAT can substitute reasonable terms for unreasonable terms. But what you'll get is, we see this from time to time for people who hire a limo for a wedding, and the wedding gets cancelled and they get stuck with a stretch limo hire that they no longer want. And the issue from the hiring company's point of view is that a reasonable estimate of what I might be out of pocket as a result of a change at this stage? But again, if you think it's unreasonable, VCAT's your answer.
Good luck, Daniel. Thank you. It's about 13 minutes past 10. We were speaking earlier today about the Human Rights Commission and Universities Australia releasing a report on sexual assault and sexual harassment on university campuses. I mentioned it was 30,000, a random sample of 30,000 students. Half of them reported harassment in the year 2016. Half of the 30,000 people part of that survey being conducted by the Human Rights Commission. There'll be more on that, I'm sure, through the morning and the afternoon. It's a fairly extensive inquiry. David's called from Kew with a query for David Whiting, our talkback lawyer. Go for it, David.
Good morning, gentlemen.
Good morning.
My wife and I are building a new house to live in, and we have an encroaching drain issue with our neighbour.
Yes.
We have separate sewer pipes leading to the main lines.
Yes.
However, we wish to do
No. Do you share any of the drain?
None whatsoever.
Because in lots of areas in the smaller houses areas in Kew, and in lots of inner suburbs, you find that there's only one point of access to the main sewer, and part of the sewer is shared.
Yeah, no sewer is shared. Our sewer pipe has now been abolished in preparation for excavation.
Yes.
And it goes to the north. Their sewer pipe goes to the south. However, an examination of the plan reveals that their sewer pipes, which are external it's a double-storey house next door, they come down the outside of their house.
Yes.
And they then encroach on our land by about 200 millimetres, and for an extent of 2 to 3 metres,
yes.
1.6 metres down. And it's exactly where we wish to excavate.
Yes.
Our neighbour is not being cooperative. I'm prepared to move those pipes at our expense, but he is resisting.
My recollection, David, is that you don't acquire easement rights by adverse possession. All right, so, and I take it this is it's on your side of the fence?
Yes.
I don't think he's got any rights at all.
But how do I get him to agree?
Well, I don't know that you do necessarily need to get him to agree. If the pipes are encroaching, then you might be within your rights to simply terminate them. Now, I don't, which would create significant angst at the house next door.
Their neighbours.
Well, he doesn't live there. He's a landlord. It's actually a tenant's property.
Look, I'm going to ask you to wait till next week, David, but certainly I'd be going off and getting some advice having regard to the cost of the building works you're about to undertake.
Yes, no, it's significant.
Or even go and get some advice this week. But my initial reaction is they do not acquire rights by adverse possession in respect of a sewer pipe. Yeah,
and there is no easement in that area. They just encroach. Our land used to be part of the neighbouring property.
And when did the separation occur?
About 50 years ago.
Okay, yeah. So they sold the backyard or the side yard and you bought it, or your predecessors bought it.
Correct.
Yes, I'm not. I don't think they've got any rights for everybody other than you, David. I'll tell them next week. Having regard to the probably $1 million or more you're going to spend on your building contract, I'd go off and get some advice.
Thank you for your help.
Thanks,
Good luck, David. We'll pick that up with homework with David next week. Look, more of the breaking news coming out of the Human Rights Commission and Universities Australia. Their random sample of 30,000 students looking at sexual assault and sexual harassment. Half of the students reporting being harassed, and the other figure coming out, 6.9% of the students reporting being assaulted in the calendar years 2015 and 2016. I have no idea how that close to 7% figure compares to other similar cohorts of young people across the country. But if you randomly sample 30,000 people, it's research worth looking at. We'll see if we can get to more of that detail later in the morning. But Janice has called from Croydon with a query for David. Go for it, Janice.
Thanks, Raph. I enjoyed the movie last night too, by the way.
Oh, good.
David, my story regards an eBay issue. My daughter placed 2 sofas on eBay for me because I'm moving house.
Yes.
One of which is a sofa bed. Now, the sofa bed was clearly opened and photographed really clearly on eBay.
Yes.
A woman purchased them after a few issues. Her son came and picked them up on Sunday morning. No mean effort getting out of the house. I received $450.
Yes.
I then went out. I came home. The 2 sofas were back on my front veranda.
Sorry, can I ask, Janice, is this a sale that took place outside eBay?
No, it was an eBay sale.
No, I understand. There's a whole lot of people put stuff on eBay and then deal direct. So when you said you got $450, is this a transaction that's subject to the eBay terms and conditions?
Yes, it is.
Okay.
Yes, it is. My daughter has actually rung eBay about the whole issue.
And they run a dispute resolution centre. What service? What's the deal?
The deal was that we are in our rights that, they should not have returned the sofas.
Yes.
There is a no returns policy.
Yes.
I received a text message from the buyer, the most abusive text message. She had even done a title search of my mortgage and is quoting me my folio number, and she was going to take out a caveat on my property and you name it.
Yes.
So we're at the stage where I've got the sofa sitting on my front veranda.
Yes.
I've got their $450.
Yes.
What do I do?
For $450, probably not a lot, Janice. The sofas belong to the person you sold them to.
Right.
So they're theirs. They're now classified as unclaimed goods.
Right.
Now, I'm not saying that you mightn't at some stage in the future have a fight over the $450. I personally don't know how much effort I'd put into a fight over 2 second-hand sofas, but they're theirs. The consumer law and fair trading and consumer law legislation gives you rights depending upon the value of the goods. For $500, I don't think you have to do very much at all.
Right.
$500 worth of goods, and we've agreed they have a market value of $450. That was the negotiated figure. It may be that all you really need to do is, you could try and sell them again.
Am I entitled to do that?
Well,
I mean,
why don't you send a text message to the other person and say, well, I'm now happy to sell them for you, but I mightn't get $450 and that's your problem. Otherwise, come and collect them.
Right, okay.
But you're not taking them back,
Yeah.
and you're moving house, and if necessary, you'll leave them on the front nature strip.
Okay, because I'm actually moving on Friday, and if they're not here, we're in serious trouble. You know, I mean, if they don't come and take them, I'm in serious trouble.
Well, I mean, for $450, I don't know that anyone's going to have a huge fight over it.
No.
You might tell them that if they're not collected, they will be disposed with everything else that you're getting rid of.
Okay, beautiful. So
All
I
right.
could in theory give them to someone else.
Well, you might see if you
left
get
here.
some nominal figure for them. Yeah.
Yeah, okay.
All
All
right,
right.
there's a limit to how much effort you're supposed to put into $450 for the couches.
Yes, absolutely. Couldn't agree more.
Okay.
Good luck, Janice.
Thanks, Janice.
Thank you. Bye.
1300 222 774 is the phone number. You're listening to ABC Radio Melbourne with me, Raphael Epstein, in the chair for a month or so while Jon Faine is away. David Whiting is here, as ever, dispensing free legal advice. Richard's in Warragul. Go for it, Richard.
Yeah, good day, gentlemen. How are you?
Well, thank you, Richard.
Good. Now, this relates to my daughter and the Eastlink and CityLink roads.
Uh-huh.
She has an account with Eastlink, which direct debit her bank as required.
Yes.
In mid-February, she apparently didn't have enough funds in the account, so they effectively closed her account.
Yes.
They sent her an email at the time, apparently, which, well, not apparently, they did because we went and checked it later on. She didn't know that had happened, so in May she starts getting...
Wasn't the device in her vehicle beeping at her?
She doesn't have a beeper in the car.
So she doesn't do it often enough. Yep,
no.
okay.
She pays the higher toll.
Yes.
So she continued to travel on Eastlink and CityLink,
Yes.
not knowing that she didn't have an account going with them.
Yep.
In May, she started getting letters from two different debt collectors, one for Eastlink, one for CityLink,
Yes.
which she entered into an arrangement to pay the money off.
Yes.
Middle of last month, so we're now in July, she starts getting fines from Civic Compliance Victoria
Yes.
at the rate of $155 a time.
Yep.
She travels the road twice a day, pretty much 5 days a week. So she's now up to, we're guessing, $16,000 worth of fines.
Right.
What should she do, or what should I help her do? Because she isn't in a position to pay out $16,000 worth of fines.
No, I understand entirely.
See if we can get an answer for you, Richard. So what should she do?
Richard, the problem, I suppose that one of the answers is that she's entered into an When did she start worrying about the tolls?
Well, she was unaware of it. They did send her an email.
No, I accept that. So why didn't she get the email?
She doesn't check her emails regularly. She just doesn't. She's not an email person.
She doesn't look at a bank account regularly?
She does, but...
She doesn't see that the tolling company's not taking money?
I guess not. She pays all of her bills pretty much by monthly direct debit.
Yes.
And I guess, like a lot of us, you just assume it happens. And if it doesn't happen, you'd get a phone call or a something.
Like an email?
Like an email.
Yes, okay,
but,
which she
yeah,
got.
but the debt collectors seem to have her phone number and home address.
All of which they will have got from from Eastlink.
Yep.
She might have my problem is that the infringement notices are not going to be in respect of every ticket, are they? There's only going to be in respect of some of them.
No, she's only started receiving these mid-July, the CityLink tickets. And at the moment,
so my question would be,
yeah,
is that if she's already entered into an instalment arrangement,
yep,
then she shouldn't be getting the tickets.
Well, these tickets go back to February. She's only just started receiving the tickets from February and March.
Right, but she's entered into an instalment arrangement with the tolling company.
Yep.
So her response to the infringement notices ought to be, I've done a deal.
Yep.
So in which case, is there evidence of the deal and evidence of the instalments?
Yeah, that's coming out of her bank account on a weekly basis.
Right. So her argument to Civic Compliance is that she would like to have the matter referred to court on the basis that there is no infringement because she's entered into an instalment arrangement.
Okay, and would that only apply from when she started the instalments in May, or would that
No,
apply
it would
right
apply to whatever fines are whatever tolling charges are the subject of the instalment arrangement.
Okay, so if she's paying off all the tolling charges going back to February.
Yes, but we don't know that. But if she is, then there oughtn't to be any infringement notices, and the tolling companies. So you want to talk to the tolling companies about having the infringement notice. You want to do both. You want to talk about Civic Compliance Victoria and say you want the matter referred to court because you've entered into an instalment arrangement with the person who advised them of the infringement.
Yep.
And then you want to go back to the tolling companies and say, hey, well, we have an instalment arrangement in place.
Yep.
What are you referring this to Civic Compliance for?
Okay, so this is...
But I can't guarantee that any of it's going to work.
No.
But
So
they are the
could-
two approaches I would take.
So this could potentially be a matter of computers spit out tickets as
Yes,
they...
could
whenever
easily
they want.
be.
Yeah, okay.
And
No,
Richard, your other option potentially, I know some of the community legal centres have run test cases against various aspects of the debt collection. It might be worth asking one of the community legal centres if your daughter's case intersects with some of their test cases.
Oh, excellent. No worries, I'll do that. I'll actually take a day off work on Friday to try and help us sort it out.
Okay, you can do most of it on the net. Most of your research you can do there.
Yep.
There are certainly arguments about what the process.
Yep, okay. No,
Thank you, Richard.
Good
Thank you
luck.
very much. Okay, bye.
It's about 27 minutes past 10. A reminder, the conversation hour coming up after 11 o'clock. We'll keep taking calls with David Whiting, but a great conversation hour coming your way. The daughter of Johnny O'Keefe, Vicky O'Keefe, on tour paying tribute to her father. Tex Perkins from the Beasts of Bourbon, the Cruel Sea, and the Bumstead Orchestra. Yet I hadn't heard of the Bumstead Orchestra either, but he's written the story of his life, Tex Perkins, and Tony Jones, who you know of as the host of Q&A and formerly Late Line. He's written a book, and he hasn't done the journo thing, the memoir. He's written fiction, and it's fiction set in the days of, well, before he was a reporter, the days of Lionel Murphy and the ASIO and so-called Croatian fascists and all, old Parliament House and rough, tough, hard-talking, hard-drinking journalists, which is, you might be surprised to learn, before Tony Jones's time. So a great conversation hour coming your way. Tony Jones, Tex Perkins and Vicky O'Keefe, the daughter of the legendary Johnny O'Keefe. I'm thinking, David Whiting, more Johnny O'Keefe than Tex Perkins,
You
your
think?
CD collection, but maybe not. Is there a Cruel Sea
I've got some
CD
Roy
in there?
Orbison, but I don't have any. I don't have any
Roy,
Tex Perkins. No.
That's okay. Tony Jones, would you read Tony Jones' fiction? It's going to be interesting.
I don't
gonna be
know. I
very
actually think there's a lot of fiction on Q&A, but that's
Oh,
there.
the obvious retort. I was saving that line up.
Oh,
You've killed it. You've taken away. You've stolen my thunder. Jennifer's called from West Footscray. What did you want to say, Jennifer?
Yeah, good morning, Ruff and David. I run a business and I have a commercial lease with a real estate agent.
yes.
The difficulty we're having is that the owners of the property have a property manager who they would prefer to be the only tradesman who works on the property. However, when we signed the lease originally, we gave them a list of things that needed to be done to the property before we moved in.
Yes.
We had 2 months before we moved in where we had lots of trades into the building and gave them ample opportunity. None of those things were done, and so we've given them, of course, all this time to be able to do things like there was asbestos tiling upstairs that wasn't replaced, and so we've eventually had to make opportunities for them to rip that out and then try and replace it. But our
Yes.
problem is every time something needs to be done, it's taking months and months and months and months to be done. So, and they're not.
But you have a
long
commercial
time.
lease
Yeah.
and you have repair and maintenance obligations under the terms of the lease.
Yeah, we do.
Is there anything in the lease that requires you to use the landlord to undertake those repairs?
Not that we can see. We've talked to the real estate agent about this, and the real estate agent is finding this as frustrating as we do, because for them, they've not been given permission by the landlord to use their own trade.
Well, in a residential tenancy arrangement, the repairs and maintenance obligation is almost always on the landlord.
Absolutely,
In a
yeah.
commercial situation, the repair and maintenance obligation is almost always on the tenant.
Yeah.
So,
This is an unusual situation, and the real estate agent had explained that to me, that for reasons they said they cannot disclose, which I think, We've been told by
No,
other people.
sorry, Jennifer, your obligations are in your document.
Yeah.
Your obligations are not in a document you don't know about or understand.
Yeah, no.
And the general proposition is that the repair and maintenance obligation doesn't require any consents or approvals. They're built into the lease. You simply do them.
Yeah.
Now, if you're coming along and saying that this is some work that is one of the landlord's obligations, so, for example, the roof tiles fall off or something like that.
Yeah, these are all asset-based issues.
Well, that may be the landlord's problem. And it may be that what happens is you simply start going to VCAT if the landlord doesn't live up to the landlord's obligations. So instead of waiting forever, I've got an urgent repair because the roof's caved in.
Yeah.
Well, you're now going along and say, well, you won't fix it. I want an order that they be repaired urgently.
Right. Pardon me.
Does that make sense to you?
Yeah, it does. We've docked some of the rent because it means that some of the building we can't actually use because these repairs aren't done.
Well, you have no right to deduct the rent. You go back to VCAT and you say, I need the rent adjusted for this period to this period because I have no access to the building.
Right.
So what you're trying to do is set up an arrangement whereby you reach an accommodation with the landlord.
Okay, yeah.
You'll honour your obligations if they honour theirs.
Yeah.
But you've got no right to withhold the rent. You should pay the rent and go to VCAT and say, I want some money back. Because I've got, I rented 500 square metres and I've got 402.
Yeah.
I therefore want an adjustment in the rent.
And what do we do when we've brought up to the owners that there's no sprinkler system and things like that and these aren't compliant?
Is there a requirement under the law for there to be a sprinkler system?
I thought that there was a requirement under the law that all commercial buildings had to be fire safe.
No.
Oh, there isn't?
Well, sorry. They have to meet fire standards.
Yes.
But there are lots and lots of buildings around Melbourne that are, maybe 2, 3, 4 stories high that are not sprinklered because at the time they were constructed they were not required to be sprinklered. Some landlords put them in, some don't.
And if they don't even have smoke alarms in them?
The smoke alarms have a different set of rules for commercial buildings as opposed to non-commercial buildings, so residential buildings. Right. You'll probably find that there's a... So what you might do is get the fire brigade will do an assessment of the property.
Yeah.
As to whether it's compliant. But I don't really want you to be unable to access your building because it doesn't meet the fire standards.
Well,
so you might talk to a... Beg your pardon?
Yeah, that was our concern too.
Yeah, but wasn't that so when you moved in?
Well, yes, and that was part of the
none of
the
which
terms
they've
that
done.
we put on the lease. No, none of which they've done.
So then you go to VCAT and say, I now want permission to do all of this work and deduct the costs of the work from the rent.
Okay.
All right. Thank you, Jennifer.
Good luck, Jennifer. We'll get to more calls with David Whiting in a moment. David Whiting is here taking your calls, and I've just found out from him he's been taking calls on radio stations across Melbourne since I was in high school. So, David, I'm impressed. I'm astounded at your commitment to the cause. Let's speak to, I'm not going to let you comment. Let's speak to Cameron in St Kilda. Go for it, Cameron.
Hello, Cameron.
Oh, Cameron, you there? Sorry, Cameron, try again.
Yeah, hi. Thank you for taking my call. Look, just a really quick one, I think. I had a motorcycle stolen about 2 years ago, which was insured. The motorcycle disappeared. The insurance company paid me some money.
Yes.
It has been recovered now 2 years later in Tasmania. The police in Tasmania are trying to return it to me because I still am on the title. I'm just trying to work out my...
Cameron, the bike belongs to the insurance company.
Okay.
So, it may well be that you'd like the bike back, and it may be that the insurance company will give you a good deal. Which is something that you might consider, but the general proposition is that your rights in the bike have been acquired by the insurance company.
Okay, and so that would be part of the policy that the insurance company puts together, and they do not change the title on the motorcycle because the police look at the title and obviously called me.
Well, I'm a very picky individual, Cameron. The register maintained under the Road Safety Act is not a register of owners. It is a register of people who are liable for the use and misuse of the vehicle. So it would be possible for you to own a motorbike and it be registered in my name, and if it was registered in my name, the tickets would come to me as the operator. Right? It's not a measure of ownership, and presumably at the end of your period of registration, the registration was never renewed. So what's happening is that the police in Tasmania are looking at a historical record based on the VIN or vehicle identification number that says this bike was last registered to Cameron of St Kilda. So you're the logical place to start, but you could just as easily tell them the bike now belongs to XYZ insurance company. I think your next decision is, am I interested in even getting the bike back?
Right.
But if you do, you've got to have a talk to the insurance company because it's their bike now.
Okay.
All right?
All right.
But it might be cheaper than what you got for the insurance.
Yes, I would think.
You'd hope so.
Good luck, Cameron.
Thanks, Cameron.
Good luck. And Joe is in Werribee. Final call. Go for it, Joe.
Good morning, David. Thank you for taking my call. Long-time listener, first-time caller. David, I recently hired a car in Darwin when I went on a holiday with my partner, as I normally do every year for the last 30 years. Never, ever had to claim on an insurance.
Yes.
Kangaroo jumped into the car, and there was an accident. I drove the car back, returned it to the insurance company. I had taken out RACV insurance to cover the excess of $5,000 for excess.
Yes.
The car was comprehensive insured by the car company.
Yes.
I put the claim in. I was then denied the claim from...
Why?
Well, RACV insurance or their underwriter...
Yes. I think it's not fair to name the insurer, but
Okay.
we're past that. Yes.
Okay.
Yep.
The underwriter in Sydney, which I won't name,
Yes.
for that company, said that we didn't have comprehensive insurance. They then rung the hire company and they said, yes, we did have comprehensive insurance, and they said, we will pay. I then paid the money. At the time, I was sent an invoice for $3,350.
Which was the amount that you needed to pay the insurer in the hire company. That was your excess, for want of a better word. Yes.
Well, that was the amount that had to be paid for the damages on the car.
Okay. Yes.
Now, I then paid that insurance because the insurance company the hire company in Darwin said if you don't pay within 7 days, there'll be a $900 debt recovery fee every day after.
Wow. Yeah.
I then paid it, but unfortunately what had happened is that increased the damages on the car from $3,500 to $4,800.
Yes.
Because there was a 26 days off the road charge that had been added.
I understand. It's not available to rent for 26 days.
That's
You therefore
correct.
pay some more
Yep.
money. Yep.
So then I paid that money, sent it to the insurance company in Sydney, and they said, no, we will only pay you the $3,300. We won't pay you the $4,800. $1,500 difference.
Absolute madness. Why?
Well, everyone that hires a car should be aware of this, and that's why I'm making everybody aware. I am a member of that particular club. I have my house insurance, my car insurance, my boat insurance, my travel insurance, my overseas insurance, and they're not honouring this deal.
Well, I don't know. I don't know what the deal is. I haven't seen the product disclosure statement. Let me ask you a different question.
Yes.
Did you pay by credit card?
Yes, I did.
What I ask you to do is have a look at the product disclosure statement that came with the credit card.
Right.
Most credit cards, not all of them, but most, actually offer you exactly the same cover for no money.
All right. Okay.
All right?
Yeah.
So, you go, I've rented cars overseas, and you get this horrible, you can, it's $2,000 a day, but you can cut it down to 10 or zero if you pay a premium of Y.
That's what I did.
What you will often find is that the excess is covered by the terms of your credit card.
Well, I went to the trouble, David, of paying the extra money to...
No, it's an incredibly generous act for you, Joe. Start with looking at your credit card. Right. There is an insurance complaints authority. There is you can take the insurance company to VCAT. You can do all of those things, and you can, for you and for everybody else, have a look at the terms of your credit card. Most of us have got more than one credit card, and you'll find that if you bought the car hire from a particular credit card company, you might find that excess is covered.
Yeah, okay, David. Thank
All
you.
right, thank you.
I'll pursue that, David. But I think it's the insurance companies and their underwriter.
It's the terms of the policy, Joe.
You might have to settle with that, Joe.
Yeah.
But look, good luck. Good luck. David Whiting, thank you so much.
Thank you, Raph.
David Whiting will be back next Tuesday taking your calls, of